I don't care. You are literally in the middle of a plea and sentencing. You are not showing respect to your client. You are not showing respect to the court. You are not doing your job. We will go on the record in the matter 25 CF 115, State of Wisconsin versus Dylan McCarthy. The state appears through District Attorney Kevin Schmidt in person. Mr. McCarthy appears in person with his counsel Glenn Keene by video conferencing. We're set for a tentative plea and sentencing. Is this matter proceeding as such, Mr. Keene?
Yes, Your Honor, and I just filed the plea paperwork shortly. I apologize for the lateness on it. I was trying to contact my other client for this afternoon, and I'd sent the proof of that to ADA Villard instead. And it called for a reduction to a misdemeanor upon proof of completion of treatment. Mr. McCarthy has that. I don't know if he's had a chance to present that to District Attorney Schmidt for his review.
Why don't you go show Mr. Schmidt?
I've already gotten it.
Okay, you're good to go. All right. So all I'm waiting for is the plea questionnaire, which has now come through. Okay, and so what kind of treatment did you complete?
CSG SUD and substance abuse, cognitive behavioral therapy skills, and substance use disorder group. I did a few of them, but this was the most recent one.
Oh, good. I'm glad to hear that. How many weeks and things were they?
The inpatient was 30 days, and then I went to the intensive outpatient was a 12-week course.
And how are you feeling?
Good.
Good. I'm glad to hear it.
Thank you.
Okay, formal motion to amend from which one would you be amending?
I need to know what it says on the plea questionnaire.
Well,
sorry. It would be the sorry, it would be amending the possession of narcotic drugs to possession of amphetamine and DRI the others.
Okay, I was just confused because there's not a possession of methamphetamine charge. It's the narcotic drugs. So I was just confused about that. I believe it's count one. So a motion to amend count one to an amphetamine.
So made.
Okay, granted. So I do have the plea questionnaire waiver of rights form in front of me, and it appears that you signed that document. Is that accurate?
Yes, Your Honor. I'm a little confused about why it says amphetamine on there. I don't know if that's a legal term or something, but there wasn't any thing of that involved in
the offer in the case was a misdemeanor. I would have assumed we maybe would have done a different one.
I would think so too, because that totally shocked me when I saw that, because I'm like, there's not a possession of methamphetamine here.
Right.
And so honestly, if you're going to get the credit of having a misdemeanor.
Okay, yeah, so that's the one I found in there. It was a misdemeanor in the statute, but if there's a different one the DA was thinking of, I'd certainly,
Sure, one sec.
And here's the deal. Mr. Keene went over everything else with you on that plea questionnaire, correct?
Yes, Your Honor.
And so I can go over, if it is amended to something else, I can go over all of that and what that means to make sure that you understand, okay?
Yes, Your Honor.
What I would suggest instead is fentanyl is a drug that can be prescribed. So instead doing possession of an illegally obtained prescription, 450.11 sub 7 sub H.
Okay, that sounds much better to me.
Yes, Your Honor.
Okay, did you get that? Okay. All right. You okay with that, Mr. Keene?
Yes, Your Honor. And that has a lower penalty than the other, if I recall correctly. I'm just pulling it up just to refresh me.
It's an unclassified misdemeanor with a penalty of $500 and or 6 months jail.
Okay.
Okay, yeah.
Okay, so Mr. McCarthy, now discarding the charge and the maximum penalties that Mr. Keene went over with you, he went over everything else with you thoroughly?
Yes, Your Honor.
Essentially word for word?
Yes, Your Honor.
And you understand everything completely?
Yes, Your Honor.
You're 27, you can read, write, you understand the English language. high school diploma or equivalent, no alcohol, drugs, or medications.
Yes, Your Honor.
Are you receiving any treatment for a mental illness or disorder?
No, Your Honor, I completed that through this.
Excellent. And on that document, there's a list of constitutional rights. Did Mr. Keene go over those rights with you thoroughly?
Yes, Your Honor.
Do you understand that once you plead guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
I do not.
You understand them and that you're giving them up?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that here, it's possession of possession of a prescription or prescription illegally? I need to get that real name down. What is the name of the possession?
Possession of a prescription drug without a valid prescription.
Prescription. Okay, so do you understand that you were being charged with possession of a prescription drug without having a valid prescription?
Yes, Your Honor.
Do you understand that the state would have to prove that you possessed medication that requires a prescription and that you did not have a prescription for that medication?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $500 or 6 months of incarceration or both?
Yes, Your Honor.
Do you also understand that there's an agreement here for costs only and for costs and for 1 year of probation? Do you understand I'm not bound to follow that?
Yes, Your Honor.
Said differently, I could sentence you to the maximum penalty if I thought it was warranted.
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over that criminal complaint with your attorney, that original charging document?
Yes, Your Honor.
And in that document, there's a section called the probable cause section where it basically says what happened that day and why you were charged with the crimes.
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you pleading guilty to possession of a prescription without a valid prescription because you're guilty of that?
Yes, Your Honor.
Mr. Keene, may the court use the probable cause section of the criminal complaint to find a factual basis along with the statement made by Mr. McCarthy. You're muted. And Mr. Keene, you're muted. Is he here? Is he there? Is he anywhere? Are you there, Mr. Keene? Can you hear me or no hear me? Nope, I don't think you can hear me. I don't know what you're doing. Are you doing something else during a hearing that you have with me? What in God's green earth were you doing, Mr. Keene? Not paying attention, not being here in our plea and sentencing. What were you doing? Because I know you were talking, I know you were doing something, and you weren't listening.
Your Honor, my apologies. My client for 215, I just called. I had not been able to reach him. I was trying to.
I don't care. I don't
understand, Your Honor.
care. You are literally in the middle of a plea and sentencing. You are not showing respect to your client. You are not showing respect to the court. You are not doing your job.
My apologies, Your Honor. I was trying to make sure I didn't have a client with a missed bond appearance, Your Honor. I was not
Again,
going to. I understand that.
Cause, not your concern during a plea and sentencing or any other hearing. Otherwise, your butt should never be on Zoom. It should always be in the seat next to your client, because that is so unprofessional. That is so unethical, what you just did. Now, I don't know where you stopped listening and paying attention to the hearing that you're involved in and where you didn't. So now I have to start over. My apologies to you, Mr. McCarthy. Sincerely. Now, Mr. McCarthy, again, I'm going to go over all of this stuff with you. Your attorney, hopefully focusing directly only on you, went over the plea questionnaire waiver of rights with you, correct?
Yes, Your Honor.
And do you believe he went over it thoroughly with you?
Yes, Your Honor.
Do you believe he went over it word for word?
Yes, Your Honor.
And all of those things, again, you're 27, high school diploma, read, write, understand English, no medications, drugs, or alcohol in the last 24 hours.
No, Your Honor.
No mental illnesses or disorders.
No, Your Honor.
Because you're charged with crimes, you're entitled to constitutional rights. Each of those rights is listed on the plea questionnaire. Did your attorney go over those rights with you word for word?
Yes, Your Honor.
And do you understand them completely?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving those rights?
Yes, Your Honor.
Do you understand that, or do you need me to go over those rights with you in any more detail?
No, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that the state would have to prove that you possessed a prescription drug without having a valid prescription?
Yes, Your Honor.
Do you understand the maximum penalty could be a fine of up to $500 or 6 months of incarceration or both?
Yes, Your Honor.
Do you understand that there's the agreement that's been reached for you to have costs and 1 year of probation?
Yes, Your Honor.
Do you understand? I'm not bound to follow that.
Yes, Your Honor.
I could sentence you to a maximum penalty if I thought it was warranted. Understand that?
Yes, Your Honor.
Now, your attorney, he went over that criminal complaint with you
Yes, Your Honor.
with those facts that allege what happened that day and why you were charged with the crime.
Yes, Your Honor.
For the most part, are those facts accurate?
They are.
Are you admitting here today that in fact did possess a prescription drug without a valid prescription?
Yes, Your Honor.
Now, Mr. Keene,
Yes,
may
Your
the
Honor.
court use the probable cause section of the criminal complaint with the statement made by Mr. McCarthy to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Mr. McCarthy, for you to plead guilty to this charge?
No, Your Honor.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily.
Yes, Your Honor.
Has your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
Yes, Your Honor.
At this point in time, are you satisfied with his services?
I am.
Okay. You have any questions for the court or for your attorney before I proceed?
No, Your Honor.
And if I didn't ask this before, he's appearing by video, right? Do you understand you have the right to have him seated right next to you, to sit there and pay attention to what's going on? You
I do.
understand that?
Yes, Your Honor.
And do you and so you are okay with him appearing by video?
Yes, Your Honor.
Any questions for Mr. Keene or the court before I proceed? Because I can send you to a breakout session in our Zoom room, or I can say you can have time to go quick, give your attorney a call if you need that. Any questions?
Not about this, Your Honor.
Okay, then as to amended count, well, formal motion to amend to possessing a prescription drug without a valid prescription.
So made.
Granted. How do you wish to plead to the amended count 1?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count 1. Counts 2, 3, and 4 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
I think at least from Burnett County's perspective, we're mostly concerned with the substances that Mr. McCarthy is using. He doesn't seem to have any criminal history up until 2021 when he gets that fleeing in Washburn County. And then subsequently, he would be convicted of another fleeing in Minnesota in which he had fentanyl and methamphetamine on him, or more precisely, a tinfoil that tested positive for fentanyl, and then some powdery substance that tested positive for methamphetamine. So that was in February. Our case came a few months later. So fentanyl is an extremely dangerous drug. It's very easy to overdose on it. Our concern is making sure people don't get addicted to it. It's extremely addictive too. So this disposition shows that because of the things he's already done, we don't need to pile on with more felony convictions. However, we still have some supervision to make sure that we're making sure that he can have the tools he needs to defeat that. Thank you.
Thank you. Mr. Keene.
Yes, Your Honor. I'd encourage the court to adopt the recommendation because as the DA pointed out, there's mostly a substance abuse issue, and Mr. McCarthy has worked diligently over the past, several months plus, taking advantages, used his, taking advantage of benefit available to him as a veteran to get inpatient treatment through the VA along with outpatient treatment. And he's been doing that so that he can, take custody and care for his child and be, and be involved in the child's life. And Mr. McCarthy has, managed for, since coming back into compliance with the court, he's, managed to avoid further legal trouble while completing treatment, which, as the court and the DA is well aware, is not always easy when you're, trying to overcome substance abuse disorders, over the length of this case. And I think the fact that he's managed to do that while making it to treatment other things is proof that a probation to provide continued supervision over Mr. McCarthy is an appropriate result for this court. Thank you, Your Honor.
Thank you. Mr. McCarthy, is there anything you want to tell me you want me to know about this and about you?
I know we touched on the substance abuse stuff, and that is just one of the biggest things that I'm proud of at this point is staying sober and remaining sober. And that is not anything I think the court or anybody has to worry about. And it's upmost on my mind, but I don't, I just see good things coming. So I appreciate your guys' help with everything also.
How long have you been sober?
Since August 5th of last year was the last time that I had used fentanyl. So I'm coming up on a year.
I'm so proud of you.
Thank you.
That is something to be very proud of. You're a veteran?
Yes, Your Honor.
Where did you serve?
In Washington State, and I did training in Fort Leonard Wood in Missouri, and then I was stationed in Washington State.
Okay. How long were you in this service?
2 years and some change. It wasn't very long.
And so you have access to VA resources?
Yes, Your Honor.
Are you on probation anywhere else?
Just in this county.
In this county?
So I got put on probation in Minnesota, and then they transferred me over here. So technically I am on probation in Minnesota, but I just am handled by Burnett County for probation.
Yep, I understand that. Okay, that's good to know. So in Minnesota, what were you convicted of?
The fleeing evading.
And how long were you on probation?
2 years in Minnesota. Or I think Minnesota had given me 3 years.
So when's your discharge date?
2030.
Okay. And the fleeing, when did that happen?
In February of 2023, I think, in Minnesota.
What happened? Why'd you flee?
I was scared. I was homeless. I was on drugs. I didn't want to go to jail. I was just making the wrong decisions. I think the biggest thing that contributed to that was the substance abuse.
You have kids?
I do not.
You do not have kids?
No, I got the DNA test back, and it turns out that I was not the father of the baby boy. So
It could be sad, it could be glad.
Yep.
Both could be either.
Right.
You have a home?
Yes, Your Honor.
Who do you live with?
Richard Cook.
You sober?
Yes.
Good friend?
Yes.
You have a sober network?
I do.
Who?
The guy I live with, I met him when I was in treatment in St. Cloud in VA. That's how I had linked up with him.
That's why you moved here?
That is how I met Rich.
Okay, but why did you move to Burnett County? Oh my God, I remember.
Mm-hmm.
Just dawned on me who you are.
Yep.
Yeah, sad. For the baby thing.
Yeah. Yes, Your Honor.
Well, it looks like you're doing good. And your mom?
Doing well.
And she's sober and she's strong in there.
Yes, she is.
Seems like a very great woman.
She is.
Okay. And I forget where she lives.
Cable.
Yeah, that's right. So it's close, but not close.
Yep.
Okay. You go to any sober groups?
I was attending AA and going to the Compassion House, and I was attending them. Now the weather's been nice. I've been doing a lot of stuff outside, so I should probably go start back and attending them again. But I was hitting them all the spots that are available in the area.
So you know what your triggers are and what makes you crave substances?
Yes, Your Honor.
Want to explain? Want to talk? You don't have to.
My triggers for me are, it could be people, certain people that I hang around. My mood, my environment.
If you get triggered, what's the plan?
I call my family, my little brother, my sister. I FaceTime them if anything's not going how it should for me.
You need probation?
I think I wouldn't say no to that. I think having probation there as a helping stepping stone would be good for me. Having resources in the community.
Sounds like you have access to a lot of resources.
Yes, Your Honor.
So are you saying that you think probation could be another helping hand?
Yes, Your Honor.
Okay. Want probation, you'll get probation. I was considering not, but because it sounds like you have a very good sober network and access to resources. But I'm not going to deny you if you feel that you need an extra hand.
Thank you.
Okay. All right. So you have went through a lot in the last 5 years, let's say.
Yes,
Okay.
Your Honor.
And I know that from other places, and I'm not going to go into it, but I do have an idea of your history, that you were homeless, and then you came back here, and I'm so glad you met Rich, because it sounds like that's a really good connection for you. I know your mom and your sister, and they seem like very good, solid, upstanding, respectable people. So that's a good source that you can rely on. Use it. Always use it. I don't think you're a threat to the community. Quite honestly, I think you are steps ahead of where someone else could be that is in need of probation. But again, I'm not going to deny it if you want it, honestly. So, what I'm going to do is I will follow the recommendation, 1 year of probation with conditions of absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol, regular or testing upon agent discretion. Are you working?
Yes, Your Honor.
Where do you work?
With Rich, he does HVAC stuff, and I've been his apprentice or laborer.
That is an excellent field to get into. Excellent. All right, so, and I'm going to say gainful employment, keep that up, keeps you out of trouble. I'm not going to order you to go to any AA meetings or other sober meetings. I highly recommend it, so you don't lose that. All right, you have 20 days to appeal. Well, actually, I'm going to order $443 in fines and fees. We have more than that in bail to cover that. So you get a check back, or whomever posted it will get the money back. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You must report to probation immediately. But first, you're going to go to the jail to get your DNA because they need that. You have the right to request it be expunged through a written letter to the Department of Justice, but Minnesota probably already has it in the CODIS system. So, but you still are free to do that. It's easy to do. Google, and it'll show you how to do it. So go take care of your DNA, go to probation immediately, get that all set up and ready to go. Address still on Kruger Road.
Yes, Your Honor.
Telephone ends in 1364.
Yes, Your Honor.
All right. Mr. Schmidt, anything I'm missing?
Nothing from me.
Mr. Keen?
Nothing, Your Honor.
All right, thank you. We are adjourned. You're gonna need a DNA thing to go to the jail. Go get that stuff done. Congratulations, I guess, but I'm commending you. You have done so much work since last August. I'm just so
Thank
proud of you. Alan appears in person in custody. We're set today in this matter for a sentencing hearing. Mr. Allen pled guilty to 1 count of possession with intent amphetamine, methamphetamine greater than 10 grams, but less than 50 grams, a class D felony. He did so on January 9th, 2026. The court ordered a pre-sentence investigation report. And the court has received that report. I have reviewed the report, and now I'm quickly going over to see if I noticed anything myself that jumped out at me as a material mistake that would need correction. The court did not note anything of concern. I believe we are dealing with 43 grams of methamphetamine. I'm not sure if that's is that the lab?
Yes, it's 43.07 grams.
3.07 grams of methamphetamine. I have received and reviewed the pre-sentence investigation report. I have late received the sentencing memorandum from Mr. Allen, but I have reviewed that as well. I do not believe that there was anything else for the court to review. I don't have anything off the top of my head about any character references or anything of that nature.
Your Honor, I did reach out to Cliff Cassidy and Mark Peterson for letters of support. They have a prior relationship with Mr. Allen. However, as of this time, they've not provided me with letters of support to that effect.
Is anyone making any statements here today?
I had asked Mr. Allen's supporters here if they wish to make any statements. They indicated they did not wish to speak.
All right, thank you. Mr. Vila, then I'm going to turn to you for your sentencing recommendation and argument, please. And before we begin, I believe that something was discussed between counsel, and then it was stated off the record by Mr. Feliski that there would be a now joint recommendation, even though the state is capped at the PSI recommendation. It's now going to be a joint recommendation argument to the court.
That is my understanding. I'll defer to defense, obviously, on that.
Certainly. To elaborate on that, Your Honor, after review of the pre-sentence investigation, its contents, as well as the recommendation made, and discussing this case with Mr. Allen, he indicated that he was frankly quite comfortable with the recommendation by the PSI. We had an agreement, as the court noted, for the parties free to argue with the state capped at the recommendation of the PSI. But given the circumstances here, I believe a joint recommendation under the circumstances would be appropriate.
All right. Okay. Thank you.
Thank you. So just to briefly remind the court how we got here, this was a situation where officers made contact with Mr. Brandon Allen at a gas station. There was a suspicious issue regarding the motorbike that he was on, with the license plate not matching the motorbike. He had a black bag in his possession, tried to dispose of the black bag. When law enforcement finally recovered it, they found the 43 grams of meth inside. So the DOC here recommends 5 to 6 years in the Wisconsin state prison system, broken down as 3 years of initial confinement, followed by up to 3 years of extended supervision, stated and imposed in favor of 5 years probation. That's what the state's arguing for, and apparently that's the joint recommendation. So 3 years of initial confinement, 3 years of extended supervision, imposed and stayed in favor of 5 years probation. The goal of this sentence should center on rehabilitation and deterrence. Going through the PSI, it's quite apparent that Mr. Allen has no substantial criminal history really of any kind. He has a couple low-level theft cases on his record. He completed a 7-month supervision term related to one of the thefts that took place in 2003. The case at hand here today is obviously a very large step up in exposure in the criminal justice system. With that in mind, I believe the court needs to address Mr. Allen's substance abuse issues while also taking into account the gravity of the offense and the need to protect the community as a whole. As the PSI correctly points out, 43 grams is a significant amount of meth.
Big ton.
It's a big amount of meth. So the court needs to therefore impose this sentence that provides Mr. Allen with the opportunity for programming, but on the other hand, hefty enough of a punishment to properly reflect said seriousness of said offense and the need to protect the general public, the carrot or the stick metaphor, so to speak. Ultimately, that's what the state's arguing for is 3 years of initial confinement, 3 years of extended supervision, imposing the state of 5 years probation. Thank you.
Thank you. I'm going to need a hefty argument as to why I should follow the recommendation. This is an S ton. It's a lot of ton of methamphetamine, a lot of ton that this is an intent to deliver, a manufacturing and delivering 43 grams of meth. And that was not denied. This is a lot of ton of meth. A lot of meth.
Thank you, Your Honor. I'd first like to address the issue of credit. Mr. Allen was brought into custody on this offense July 10th of 2025. He was then released on bond on October 29th of 2025. He then was brought back into custody on this matter on December 4th of 2025 and has remained in custody thus since. By my math, I have 223 days of custody credit. As was noted by the parties, Your Honor, this originally wasn't a joint recommendation. We were going to be free to argue. I communicated that as much to Mr. Allen that we could argue for time served. We could argue for a lesser sentence. We could argue for a lesser sentence with probation. We were free to argue whatever sentence we would like. In review of the PSI, what struck me about Mr. Allen's response was how much he was willing to accept it. As the court noted, this is a substantial and extremely serious matter. This is a substantial amount of illicit controlled substances that were located on Mr. Allen. There is a reason that this is a Class D felony. There's a reason that the maximum penalty for this type of offense is so high. As the court has often noted, methamphetamine is a plague on this community. It's a plague on this country as a whole. I'd go even as far as to say that it is a plague on society writ large, no matter where you go. It ruins lives. It destroys people. It breaks apart families. It is fundamentally incompatible with a peaceful, polite, law-abiding society. Mr. Allen has spent 223 days, every second, every hour, every moment, sun up to sundown, thinking over his accountability, his responsibility to society, to this community for the commission of that offense. And in reflecting on that, Your Honor, I think he understands first and foremost that this needs to be the end. This never should have gotten to this point, but this case, this matter, this needs to end here and now, because if it does not, Mr. Allen knows that his life is on the line, his family's life is on the line, his children's life is on the line in his absence, in the ways that his actions impact and affect them directly and indirectly. This needs to be the end. And it's out of consideration for that. It's out of consideration for his need to address the substance use issue, which I believe, Your Honor, is at the heart of this matter, of Mr. Allen's past criminal history. It's the need to address the coincidental mental health issues relating to grief and trauma. These are the reasons for why we are going with the joint recommendation for an imposed and stayed sentence with probation. because Mr. Allen understands that he needs to be held accountable. He needs supervision. He needs someone looking over, making sure that he is doing what he needs to do, what he has to do in order to reintegrate into society. He understands the gravity of that. He understands that, frankly, this PSI is a gift. It is unusual for it to make a recommendation in this manner. I think in large part why it does is that it identifies what the core issue fundamentally here is, which is, again, I would say a coincidental mental health and substance use issue. As the PSI and as the sentencing memorandum noted, Your Honor, this all seems to have started when Mr. Allen lost his brother in the line of duty. His older brother, my understanding, served in Iraq and tragically lost his life there. From that point, from what I can tell in my conversations with Mr. Allen in review of the PSI, it seems that a cycle began to emerge. He took substances to grapple with the pain, the grief, the anger, the trauma. He realized that he had a substance problem. He addressed it, moved on with his life, and then encountered another crisis. Once again, he relapsed, went back to methamphetamine, realized it was a problem, addressed it, moved on. Same thing happened. Crisis, relapse, readdressing, moving on. The point I'm making here, Your Honor, is that I think the PSI in part characterizes Mr. Allen as not taking this seriously. And I think under the circumstances, I can understand where that perspective is coming from. But what I would clarify on this is that he's not minimizing this. He's recontextualizing it. He understands that this is not simply an issue of I use meth and I need to stop using meth. It's an issue of I'm using meth because there's something inside of me that's broken that I don't know how to deal with. And he's kept coming back and back through that cycle again and again because of that underlying issue. In the time that he's had, Your Honor, to sit and think about what got him to this point and what he needs to do and what has to happen going forward, he realizes that it's both. It's addressing the substances. It's addressing the substance use. It's addressing the environment that he's in regards to the people that he's around and the relationships that he builds. But it's also about understanding why it is that he ends up there. It's about understanding what he needs to do to avoid getting there. An ounce of prevention, Your Honor, is well worth a pound of cure. I think Mr. Allen understands that. And I think, again, in light of that, that is why he does wish to have a joint recommendation here and accept probation along with this very, very hefty sentence. In the course of my representation of him, Your Honor, I believe Mr. Allen is at his best when he's helping others, when he's out in the community, when he's developing positive relationships, when he's around positive people. I think that's when he shines. I think that is the key here that will unlock a very bright future for him. I think he's driven and ready to succeed. I think he demonstrated that by being the first inmate to graduate here at Burnett County Jail in the HSCD program. I think he demonstrated that, as was indicated in my sentencing memo, with his intent to get healthcare and follow up with employment programming. One additional thing that I did note, Your Honor, and that has been noted by this court before, is the issue of association. When imposing a sentence, it's critical to assess how long or how short that can be and what the ramifications of that decision can be. Too short of a sentence, they're not learning their lesson. They don't understand the gravity and weight of what they did. Here, my concern would be that if Mr. Allen were to immediately enter into a substantial length of custody, that would do unintentionally would lead to him creating bad relationships with bad people. It would put him in an environment without supports that he needs from positive people in the community that are going to keep him out of this type of behavior. With all that having been said, Your Honor, I think looking at the Galleon factors here, that the recommendation by the parties with the PSI is appropriate. The recommendation for an imposed and state sentence of 3 years of initial confinement and 3 years of extended supervision is a substantial amount of time hanging over Mr. Allen's head. He knew that it could have been a far higher amount by entering his plea to begin with. He's here today to take accountability and responsibility for what happened and understanding that he needs this incentive, this stick, so to speak, to keep him accountable. In protecting the community, recommendation here for 5 years of supervision through the department. That's a substantial period. That's a very, very long time for him to be on his absolute best behavior, because he is well aware and knows if he doesn't do well on probation, if he doesn't do what he needs to do to address this underlying problem, he's going to have no choice but to have to address that problem in a confined setting in custody. I think here the recommendation for an imposed and state sentence with probation is appropriate stick and carrot. Additionally, Your Honor, Mr. Allen will have access to programming through probation that will allow him to address this underlying issue and keep him involved and invested in the community. Again, if he's not able to do this on his own, this recommendation will ensure that he must address it by being revoked and sent back into the prison system. In regards to Mr. Allen's rehabilitative needs, Your Honor, I think again, the PSI statements by the state and by the defense here make clear that this is at its heart a substance use issue. Mr. Allen knows this, he acknowledges it, and he's doing everything that he can in his position thus far to address it, and will be doing everything he can once he is out of custody going forward, whether that happens today, tomorrow, a year from now. In my conversations with him, Your Honor, I picked up on a few things. The most important detail is one that to me is very indicative in my line of work about whether I'm going to see someone again or not in this role. And that's that he acknowledged that he has a problem. He's not trying to duck responsibility, Your Honor. He's not trying to avoid taking accountability here. He's agreeing to a substantial amount of probation, and he's agreeing that if he doesn't meet those terms and conditions, if he doesn't do well, if he's not on his very best behavior with the department, that there is going to be a punishment for it. Put differently, Your Honor, I'm in a line of work where a lot of people want to avoid trouble. They want to avoid a certain outcome. They want to avoid accountability. They don't want to go to prison. They don't want to go to jail. They don't want to do probation. They don't want to pay a fine. They don't want to do programming. They don't want to do anything that someone is going to make them do. That's not the case with Mr. Allen. Mr. Allen knows that there's a problem here and that he knows he needs to address it. He knows that if he doesn't address it, it's not going to go well for him. It's not going to go well for him here. It's not going to go well for him going forward. He is extraordinarily blessed to have a loving and supporting family through his mother, through his children who have been with him, who have stood by him, who have said, despite this, we know your heart. We know your character. We know this isn't you, and we understand that you need to take accountability on this. But we're here for you. I think that was when Mr. Allen is released from custody, I have full confidence in his ability to succeed. It would cause me a great deal of pain if he were not to do well. I don't mention that often because frankly, I don't like to get personally involved in these sorts of matters, but Mr. Allen has struck me. He struck me as someone who made incredibly poor decisions and ended up in a situation where his very life was on the line and still is. He's handled that with grace, with candor, and he's ready to put his best foot forward, Your Honor. I think the agreement here reached by the parties is appropriate. I think it addresses the galleon factors here sufficiently. And I would ask this court to follow the agreement. Thank you.
Thank you. Mr. Allen, this is now going to be your opportunity to tell me anything that you think I should know, anything you think I should consider, things that you think may need to be corrected or need to be stated in more detail or depth. You also need to tell me, because I'm interested in knowing whether or not you have any treatment lined up, whether or not you have a plan for the future, what it is that you're thinking. And if you're reading a statement, I need you to read it slowly. I need you to enunciate your words. My court reporter needs to be able to take everything down, and I need to hear you.
I'll try my best. I'm kind of,
If it's
Super
emotional,
nervous.
take your time, stop, take some breaths, then continue.
well, okay, I wrote this a little while back. When asked about my true feelings about this incident, I don't feel as though I've been able to fully express myself or to be interpreted as I see fit. I feel writing my true thoughts under stress is the best way. So here goes. I hate drugs. I despise crime, and I cannot stand criminal behavior, which leads me to the feelings of constant regrets, depression, and full hypocrisy, feelings that I struggle with daily. I follow all the laws to the best of my abilities, which have gained me my best reputation and rapport with those that I have in my life. Knowing what pleading guilty would fully do to my life, my reputation, my credibility, all that I've worked my whole life for, I still chose to be 100% honest and accountable for this crime. Not for sympathy or any other angles, but because it's the right thing to do. I committed this crime, and I don't believe in wasting anyone's time by taking it to trial or attempts to downplay it, because that's who I am and who I will always be. A 100% honest and genuine person struggling with my own demons. It's hard for me to express in words the full effect that my time in jail has taught me, or the way it's redefined my moral compass, because it is something that's in my every thought, every second of every day. Webster's dictionary defines the word accountable as follows, as an adjective, being the one who must meet an obligation or suffer the consequences for failing to do so. I feel as though the past 8 months I have paid for this many times, with many seconds spent regretting my actions, as well as feeling the sting from my guilt and remorse with those I've hurt and have had to suffer with me being in here. Guilt, remorse, the feelings of responsibility for wrongdoing, regret, self-reproach, shame, and penitence are all feelings that come to my mind at a regular basis while waiting for my sentencing. The world did not stop spinning since my arrest and has created a world for me to face at a different level upon my release, which I am learning to do so daily. My reasoning for drug use has been nothing short of an excuse to mask my true feelings over grief and loss, which from learning from fellow inmates in here, I am fully capable of overcoming given my new outlook on my life. Taking it upon myself, I have developed my own personal program for handling my feelings geared towards overcoming the feelings, which I've spent the majority of my life masking. Preventative mentality is all I have to offer to prove this cannot happen again. All stemming from what I believe to be the most important question of all, not asked during my PSI, was what I have learned while being in jail. I've learned more in 8 months than I have from any treatment program, learned from observing and empathy. I can honestly say with all my heart that I do not belong in any facet of life other than being a loving and present father, son, and a man who sets examples to follow and strives for success in all things. You asked me if I had any plans for once I am released. I know that there's a couple of places in town here that are offering like Aurora, I believe it is, for help getting my Badger care up and running, which would also help me with my education. Ultimately, outpatient treatment is something that I would be seeking. I'm not quite sure if it'd be through Superior or if there's any more places local. I spoke with a lady a little while back about psychotherapy, possibilities of looking into that. Work, I got an application all set to go today to the bar/restaurant that I worked at, but not as a bartender. It would be in the kitchen. Basically trying to do my best to slowly plan it out so I don't bite off more than I can chew, but at the same time, keeping myself and holding myself accountable so I don't put myself in a position that is gonna basically start everything all over again. While in here, I started that by basically blocking and deleting my entire friends list on Sidnet, with the exception for my mother and good friend Jennifer behind me. I believe that that was the start of it. I believe that if I'm not in a setting or if I'm not around people that are using, I'm 100% confident that I will succeed in this. Mr. Feliski did say that one of the when I'm most happy is when I'm helping others. I even came up with a program that I thought would benefit felons or addicts, but in doing so, I realized that maybe I should hold off in helping addicts until I'm able to help myself.
Yep, that's a big one.
So, I mean, I want to help everybody. I always do. I mean, my mother will tell you that, but yeah, that couldn't be more real to me right now. I'm not ready to help people. I am ready to help myself though. Thank you.
Thank you. There is no ifs, ands, or buts about it at all, not one bit, that this is a very serious matter, extremely serious. No question there. 43.07 grams of methamphetamine, weighted grams of methamphetamine. That is an S ton, and I'm just not swearing here. That is an S ton amount of meth. 3 grams is intent. You can get charges for intent and deliver, for selling, for dealing. 3 grams. You had 43 grams of methamphetamine. That is not a little bit of meth. That's a lot of methamphetamine. A lot of methamphetamine. So very serious, out of the gates. I was extremely jaw-dropped when I read this pre-sentence investigation report. My jaw dropped when I read the recommendation. Gonna be honest, I'm gonna be blunt, I always am. Mr. Allen, you are a likable person. I like you. I truly do like you as a person. Me liking you and me doing my job and what is right in my job are 2 different things. I like you. I respect the fact that you worked extremely hard to get your GED. So proud of you. I cannot tell you how much that means to you, to your family, and it means something to me. You did that. You didn't have to do that. You could have sat in jail and you could have just sat and twiddled your thumbs and wanted the time to go by, but you took advantage of the time you had in custody and you got your GED and you helped others doing that. You helped others succeed and accomplish that too. So there are many things about you that I like, I respect. I think you are a good person. I see you have a good heart. I've seen your family come and support you. I've seen your daughter thrilled when you got your GED. I've seen those things. Those things make you human to me. I try and have everyone that's seated in that seat right there be a human to me and not be black and white paper. Because black and white paper, then you're simply looking at all of the bad and not allowing to see the good. I see the things and I understand to the best of my ability with my personal experience, my professional experience, and all that I've gathered in my many, many, many years on earth, that there's more to a person than the black and white. All right. And you have to take all of that into account. And for me to do my job and to do my job well, I need to see you as a human, as a person who has faults, who has issues, who has the good, the bad, and the very ugly. And that comes into account in all of my sentencing. So I see you. And I hear your words. To me, I'm going to tell you, and again, I'm going to be blunt. I liked them. They're good. They came across. They had a good, that was a good topic, good foundation, good things to back it up. It seemed like you were giving me a speech. The dictionary defines. This is what it says. It seems like you were trying to sell it to me that you do understand, or that you get it and this is what it is, and like you're trying to sell it to me that you're telling me what I want to hear or what I should hear in order to follow the recommendation, because that's where we should go and let's go on probation. I've heard more heart from you at your GED graduation speech than I heard in that. And that was supposed to be a speech. This is supposed to be a, hey, judge, this is where it is and this is what's happening. It's not supposed to educate me on what the dictionary defines something as, or what I should see, or how I should see it, and where it should fall into play. This is where you are essentially begging for your life. And you should be telling me all of the things that you've already planned. I've already talked to Teen Challenge. I've already talked to, Betty Ford. I've already talked to the place in Florida. I've already talked to the place in Texas. I've already done these things. I've already arranged and set up a treatment, an inpatient treatment facility with a bed, and it's lined up if I'm able to go. And that is at the mercy of the court, and court, please see this. And I've set it all up and this is what I've done. I don't hear that. I see individuals who have substance abuse issues every day. But I'm going to tell you and be honest, I don't see them sitting in that chair, people with substance abuse issues in the chair like you are today. 43 grams of methamphetamine. You do not have an extensive criminal history. I think there was like two thefts or something of that nature. Nothing big. I don't know if that's because you haven't been caught at doing things. I don't know if you really do follow the law and you just slipped. I understand pain. I understand loss. I understand death. I understand feeling like you want to give up. I've been there. I've had loss too. I don't turn, nor has many other people seated in that chair with substance abuse issues turned to 43 grams of methamphetamine and intent to deliver, and that devastation and destruction. They turn to self-medicate, and they self-medicate, and they have, and they do, but not all of them sit in that chair with the heaviness that you have on your shoulders today, that you placed on your shoulders today. And you were given a chance on bail with certain conditions. You violated those conditions. Wham, bam, straight right back to using methamphetamine. And I think, didn't you say your cat died? That's why. And that was the reason, that was the excuse. And it's a poor excuse, your cat died. And so you went back to methamphetamine. Instead of reaching out to somebody else, instead of trying to go to your mother, instead of looking for a meeting or any other thing, your cat died. And so you're like, blah, I'm giving up now. I'm going to use again. When you knew you had so much on your shoulders at that time, so much to risk and to lose, $2,500 in cash that I believe your mother put up, that the court had every legal right to forfeit and to say bye-bye to that money. But I didn't, because I knew that that would actually hurt your mother. I get it. Pets are like children. I had my pug for 17 years. I lost her. It's hard. You reach out to other people. And at that time, at that particular time, you had also told the court you have learned all of these things that you recited in your letter. And I get there are relapses. I do the treatment court. I get those types of things. But not everybody has the weight on their shoulders that you do. 43 grams of methamphetamine. Mr. Feliski made a good statement in his argument. He has went to the depths of his soul to argue for you here today, because he knows how serious this is. And he made a really good statement about your associates. I believe that his association and who you associate with. He's very correct. And I have heard you say that you've changed, you've deleted all the people out of your phone and out of your contacts and all of those kinds of things. You haven't been out of custody long enough with this over your head to have those kinds of things fully sink in yet, because you've been in custody. It's so much easier to maintain your sobriety, to have the positive outlook, to do those kinds of things while you're in custody. But once you are out of custody, you don't have that confinement. You have forced sobriety right now. And you don't have that confinement to ensure that you're not going to use. And again, that's why the treatment is important, or a treatment aspect is important. And it shouldn't be upon me to tell you to look at those things or to get a plan or to have something in place just in case, or if the court were to go along with probation. It's not on your attorney, but you know, that could be a way to try and have the court follow a probation recommendation. It's on you. You're the one who is changing you. You're the one who has to look at making your life better and doing better and showing me that you're not going to be a threat to my community, that you're not going to be a devastation of destruction to this county or to any other person. And all I've heard is, well, maybe there's Aurora, maybe there's some other outpatient things in this county, maybe there's things. I don't think you've went through that process of admitting to yourself that this is real and this is really serious, and you are fighting for your life. And I stressed to you, as I stress to everybody that I take a plea with, especially a plea of a serious nature like this, that you understand, I'm not bound by anything. I'm not bound by this recommendation. I'm not bound by the state's argument. I'm not bound by Mr. Feliski's argument. I'm not bound to listen to your plights and requests. I'm not bound. And the reason I'm not bound is because my job is to look at the community, the public, the interest as a whole. I have to look at you in the first process, in the first part of this, and am I protecting your constitutional rights? Are you getting everything that you're afforded, plus any victims that are here? But then after that, I have to look at the community, protecting the public, and those types of things. And when Mr. Feliski was saying changing the associates and or your association, you have to change. And I didn't hear that in there. I heard the skirting around it or the brief touching of it, that you want to do these things, but you have to do these things. You have to change your habits, the things you do, the things that you do that are so ingrained. You have to change your associates, the people you're with, not just removing them from your phone. You have to change those. And then you have to work on changing yourself. That is the only way you're going to significantly improve your life. You can't surround yourself with people who are putting you in those types of situations. You must surround yourself with people with who are positive supports that can influence a positive change and who can help you align with good, positive goals. That's the only way you're going to change your life. Again, I have to weigh certain things, the nature and the gravity of the offense. This is very serious. I have to look at you, your character, your past criminal record, which is very slight. I have to look at other things like rehabilitation. Do you have rehabilitative prospects? Are there other things out here? Your age, your education. I have to look at your culpability. I have to look at this crime itself. And then I have to look at needing to protect the public with a crime like this. And then it comes down to other factors such as deterrence. There's specific deterrence. I need to have a punishment that not only deters you specifically from doing anything like this again or anything similar, but I have to look at general deterrence, something that's going to generally deter others and say, you know what, why would I even engage in that? If I do, wham, bam, slam the door. Okay, because this is so serious. I have to look at deterrence, you and generally others. And in this deal, I've heard the arguments of the state, and the state is bound. They are 100% bound. They could not go into it. Mr. Vila did not go into any in-depth about anything. He's bound by this recommendation of probation. I've heard the arguments of the defense, and it was very heartfelt, very full, very solid. And I also heard your statement to the court. And I've read the criminal complaint, and I've been here throughout the entire process of this case. You have a felony bail jump that was dismissed and read in. All in all, you have these two charges that, if found guilty on both of those charges, you would have the maximum possible penalty of 31 years of incarceration. You didn't get the greatest of all, great of all deals, and I'll admit that to you. And you pled guilty to the charge, I believe, that you were charged with. You pled guilty to the intent with the possession with intent, amphetamine, methamphetamine, greater than 10, but less than 50 grams. And that was the charge that you were charged with. You got rid of a possession of drug paraphernalia and then that felony bail jump. So it's not like you got this sweet deal. You got a good deal. You did plead guilty, and that shows something. All right, you pled guilty, you accepted responsibility, and you were like, hey, I understand. I did this. It's hard to fight 43 grams of methamphetamine. It's hard to do that. And so you are taking that responsibility. And I do give you credit for that. Not everybody in that seat would do that. So that goes on the positive favor for you. But here, the dispute here today with sentencing, I have to look at, is this a prison sentence? Is this an imposed but stayed prison sentence? Is this simply a probation with a withheld sentence? And I do have the joint recommendation of all three of these entities coming together, arguing for an imposed but stayed with probation. And so I have to determine what is a correct sentence here. What is it that I need to look at? If I'm looking at probation, I have to look at certain things. If I were to place you on probation, I need to consider, if I put you on probation, there's multiple things that I have to think about because probation is the first thing to consider. Now, would you need confinement? Do I need to confine you to control your criminal behavior, to stop you from doing criminal acts? Do you need some type of treatment, and can you get that treatment outside of a confined setting? Or does it look like the confined setting is the only way that's going to force you to have you get the treatment that you need? I have to look at, if I put you on probation, would it unduly depreciate the seriousness of the offense? Okay, those are what the things that I have to consider. If I do a sentence of confinement, it has to be the most minimum amount that's consistent with the protection of the public, looking at that, with the gravity of the offense, the seriousness of this offense, and your rehabilitative needs. And I know the facts that is alleged in that criminal complaint. I know the statements that you've made. I know that you first said that this was personal use. 43 grams is a whole lot of personal use. That's a whole lot of grams of methamphetamine. And it's hard to have people understand that the size of 43 grams compared to a regular personal use amount. Without me showing the displays that I have, but it's a lot. 43 grams is a lot of methamphetamine. That's way beyond personal use. And so if you look at that and what the intent is behind that, again, that is participating in the devastation and the destruction of our county. I don't have any history that you've done that before. I don't have a history that you've engaged in other things before. But again, I don't know if you just haven't been caught or if this was the first time. This is the first time, man, you have the worst luck ever. Because that's a lot of methamphetamine. Again, I think you have a good heart and I think you are a good person. I think you've done some really stupid and dumb things. Some devastating things. And so in a case like this, I've reviewed the PSI multiple times. You started using methamphetamine when you were 15 years old. You're 39 now. Nothing has changed. What has changed? And I've heard that you've made these steps to try and change your life and get on a better path. But it's been 24 years. I haven't heard a concrete plan of you're going to engage in treatment. You've made the plan for this treatment. You've looked at this service and you've looked at these things and you're looking down this path. And with 43 grams of methamphetamine, I can't sentence probation. I can't. It would unduly depreciate the seriousness of this offense. It would send a terrible message to the community. It will not meet the deterrence factor of deterring others and you from engaging in this type of behavior. There has to be a punishment factor. This is a punishable sentence, a punishable crime. 43 grams. But I am taking all other things into account because I've said all of those positive things for you. I feel you can change. I haven't been shown again that you have made the steps to do that, and you need something to move you in that direction to do that. So this is a prison sentence. And it doesn't make me happy to do this. But I have to do my job. This could be up to 15 years of initial incarceration and 10 years of extended supervision, maximum possible penalty, 25 years. The $100,000 fine potential. What the court is going to do is I'm sentencing you to 1.5 years of incarceration with 5 years of extended supervision. Anything else would unduly depreciate the seriousness of the offense. And it's at 1.5 years of initial confinement simply because of all of the positive things I see in you, Mr. Allen. Otherwise, it would have been far more. But I cannot with this seriousness do anything less than 1.5 years of initial confinement. $518 in fines and fees. You do have more of that in bail, but child support is requesting that that be allocated over to your child support as you owe a significant amount in child support. So the court is directing that the remainder go to your child support. You have to work that out with your mother. And that is for case number 11 FA 70. When you are on extended supervision, well, first I'm going to say I'm making you eligible for the substance abuse program or the challenge incarceration program. And another reason I did 1.5 years instead of just a year, because I was considering that, is because that gives you enough time to get in, get processed, and get doing that program. So apply right away. Because I have not seen, if I had seen you or heard you come in and say, I have Teen Challenge arranged right now, I have the place in Florida arranged right now, I have this place arranged right now, if it's a go from the court, that would have weighed things a little bit differently. But without that, with knowing the seriousness of the crime, I cannot. And I have to look at other options and other things, because I'm going to tell you again, I understand and I feel your pain when you lost your cat. But if that was enough to have you jump right back to using methamphetamine, I don't know what is going to help you not without actually having the resources. And if you're going to start using again, chances are highly likely that you're going to go down this path again. And I can't have that. No use or possession of any illegal drugs, substances, or paraphernalia. Absolute sobriety. No bars, taverns, or liquor stores. This includes employment purposes unless approved by your agent. No contact with anyone with any drug-related extended supervision or probation unless approved by your agent. absolutely zero contact with anyone who has intent to deliver or possession with intent of any type of drugs at all. Gainful employment. Testing upon reasonable or regular testing. Any programming as required by your agent. AODA assessment and follow through. Mental health and therapy evaluation and follow through. I'm ordering your DNA. You have the ability to request it be expunged through a written letter to the Department of Justice. I'm not sure this classification allows you to have it expunged, but you can request that. 223 days of jail credit. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. This is a felony. No use or possession of any firearm. No voting until your civil rights are restored. I believe that covers everything, Mr. Vila,
I believe so, Your Honor.
Mr. Felisky.
I believe that covers it, Your Honor.
All right, thank you. Mr. Allen, I truly meant everything that I said positive about you. I truly do.
One thing I'm saying, keep it. Right? My wife people like that. She had an address and like that.
I'm not asking about your fiance's address in Wyandotte.
I didn't have an address on that name.
You said a few moments ago,
Be quiet, totally.
stop interrupting me.
Oh my God. Just
You said a few moments ago, sir, that you were coming from 6th and Goddard because that's where you live.
that's where I picked my daughter up from him that morning. And I dropped her right back off.
I'm pretty certain you said that's where you live.
Ma'am. That's where I live now.
Sir, your attorney has told you a number of times, don't talk when I'm talking. Because see the recording right there? That it can record one person at a time. Stop talking when I'm talking. You stated that's where you lived. You said, I live at 6th and Goddard. That is what you said, did you not?
Yes, ma'am.
Okay. But you don't live there.
No.
All right. So tell me about your 3 warrants that you have, sir, and what you're doing to resolve those.
Well, I have a traffic warrant in Detroit, but I'm on DPF tethered right now. So that's just a matter of payment issues. And right now I owe a $325 payment for no registration to Lincoln Park. And that's all it is.
Well, why haven't you paid it, sir?
Man, I don't have been going on right now. Man, I'm on a fixed income right now. I'm making $312 every $312 a week right now. $612 every 2 weeks until work starts back up.
Sir, don't you think that you would make more money seeking employment during the off season than you do on unemployment?
Yes, but I'm going back to work, man. I'm going back to work.
That's great. But then for 5 months, you're not working and you're receiving minimal income. So my question, sir, instead of waiting for unemployment to come and just collecting unemployment, it would seem that it would make a bit more sense for you to go get employment for even the 5 months that you're not working as opposed to collecting unemployment.
Well, that's a stipulation with unemployment. You gotta fill out applications every week. So I'm just waiting for a call, man. That's what it is. You got a job search while you're on unemployment. So
I understand that. And so you didn't get one at all. You didn't have anybody call you for an interview or otherwise. Okay.
I've only been on unemployment 4 weeks now.
Okay. So, sir, these warrants are from June of 2025. And you've only been on unemployment for 4 weeks. So why didn't you take care of those back in June?
Well, I went to jail for one of the matters, ma'am. And then I got out and I paid one to get
Which matter was that?
for the driving on with no proof of insurance. And then the other ticket was no registration, which that's what I owe right now for Lincoln Park, which is $340.
Which is for disturbing the peace.
No, that did not dismiss.
No, it didn't, sir.
The disturbing the peace?
Sir, I'm looking at it right here. You have a conviction from September 26th of 2025 in Lincoln Park. And in fact, you have a warrant that was issued February 3rd of 2026 because you did not appear.
For a payment review, right?
I don't know what it was for. It says failure to appear. So let me just go through this in just one moment here. In 2025, sir, January of 2025, you have a conviction out of this court for disorderly conduct. All right, that was the charge. And you pled to disorderly conduct. And what was your sentence out of this court, sir? Did you have fines and costs or were you on probation?
Fine cost, man.
Okay. Then, sir, you have in September out of the city V course, you have another disorderly conduct.
That was disturbing the peace now.
Disorderly conduct, disturbing the peace. They're used actually disorderly hyphen disturbing the peace is what it's showing in the 25th District Court.
I'm looking at the PSI. I don't see that, but I'm not.
Yes, it is. It's on the first page under criminal history.
On the third page,
First page on the first page of the PSI under criminal history.
I see fail to obey an 03.
Yes, go to the last one, 2025. That's Lincoln Park. Disorderly. Disturbing the-
936.
Right.
Right. That I see. But I also, I do
Did you
not
get the
see.
amended one? There was an amended one that was done that showed the wind out one.
No, I don't.
Okay, that was January 23rd. So what I see, sir, is this. This paints a picture for me. A picture of somebody that is continuing to be unable to control his emotions. You have a disorderly conduct in Wyandotte. Then you get one in the city of E course, which is within the 25th District Court in Lincoln Park. That's why it's showing Lincoln Park. Then that's around the same time as you got the one in Lincoln Park. In fact, right before that is when Mr. Mazguy was victimized by you, sir. So what I see, sir, is an individual with escalating emotions that doesn't know how to control their emotions. That's what I see. You had zero reason to pull over. Zero. No reason to pull over whatsoever. And then not only did you pull over, you get out of your car and then you start walking up to Mr. Cunningham or to the area, wherever you intended to go. You put your hands on an individual with such force, sir, that he fell backwards, fractured his wrist, did something to his elbow, and was knocked unconscious. With one time that you touched him with such force. That was what happened as a result of your actions. You could be mad that he pulled out in front of you, he turned in front of you, whatever it is, sir. You have the right to be angry about that, frustrated, whatever it is. You don't have the right to act upon that anger in the manner in which you acted. None. Counsel, I asked for the recommendation.
I've indicated, Your Honor, the amount of restitution requested still doesn't show any out-of-pocket expenses to Mr. Cunningham. As such, until that is shown, restitution, I mean, who gets the restitution? Is my question. Is this a bill from the hospital that
It's a bill from his insurance. It's a statement from his insurance company that they did not cover that. So here's my question, counsel. If Mr. Mazguy doesn't have that money to pay out of pocket and he has to pay as he gets it from your client, I'm sorry, Mr. Cunningham, if he doesn't have the money to pay out of pocket and that one lump sum, then your proof of payment is not going to be there at all. So perhaps, and I don't know, maybe Mr. Cunningham has to wait until he's paid restitution by your client before he can pay that bill in full. I have no idea.
I understand that, Your Honor. This doesn't, and I just saw this, when this attached. This appears to be claim was put into the hospital, and according to Mr. Mazdai's testimony, this is rejecting the claim. It's not
Mr. Cunningham's.
Mr. Cunningham.
Yes.
I don't see where this document says that.
All right. So what I'm going to, I'm going to direct Mr. Cunningham to just get something from his insurance company indicating that he is the one that's responsible for that balance. There you go.
Once we get that, we can figure out the exact amount.
Great. All right. Anything else?
Other than that, Your Honor, Mr. Mazdai has indicated that we're asking the recommendation be adopted.
Here's what this court's going to do. This court has serious concerns regarding Mr. Mazguy and the safety of this community, any community, quite frankly, because Mr. Mazguy, as he's even indicated, doesn't even know Mr. Cunningham, yet behaved in this incredulous behavior with somebody he didn't even know, with his 4-year-old daughter in the car. And it's also clear to this court that Mr. Mazguy's behaviors continue to escalate. And so Mr. Mazguy definitely needs some assistance in managing that anger. The court's going to note, after hearing from Mr. Mazguy, Mr. Goldpaw, Mr. Cunningham, that in review of the report, the recommendation, the police report, the criminal history of Mr. Mazguy, the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Mazguy. The court's going to order 180 days jail. The court's going to suspend 150. That means you're going to serve 30 days jail. The court's going to also indicate that upon your release from jail, you're going to be sentenced to 24 months probation. You're eligible for early discharge with a hearing. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to have any contact with the complaining witness in this matter, Mr. Cunningham or Ms. Hillier. I'm also going to include Ms. Hagerman, as she was in the vehicle as well. That's phone contact, text message, email, social media, third party, anything of the like. You're not to go to any of their homes or places of employment. You're not to possess any weapons or firearms. Do you have any of those, sir? I can't hear you.
No.
You are to participate in a 12-week anger management class. The rehabilitative goal for that condition is so you can further have an understanding and some tools whereby you learn how to properly manage your emotions when you are in an upsetting situation. And then the court's going to order mandatory jail for any violations. Sir, you're looking at your charge, your conviction is for up to 1 year in jail. All right. I have now sentenced you to 180 days in jail. That's half of that term at this point. And you serve 30 of those days.
No.
This behavior is not tolerated at all.
Yeah, can I ask a question?
What's that?
Can I have a little time so I can get this unemployment, a couple more checks for the van? Cause I mean, I take care of the household, I'm the head of household. So can I have a date to turn myself in for the 30 days, ma'am?
So, sir, here's the thing, right? I'm not giving you a couple weeks. So it's not going to be a couple more paychecks. And if you're set to go back in April, that's next month, right?
Yeah, cause I'm on GPS tether, that's why I asked you, ma'am. I'm still on tether.
I understand that.
So
But sir, this 30 days is part of your punishment for the behavior.
Your Honor, would you give him 1 week?
No, not give him 1 week. The most I will give him is till Friday. That's it. March 27th.
And he will go to Wayne County Jail.
Yes, you're going to go over to probation. You're going to get all of your next steps as how you go and report to from jail, sir. Yes, it finds a cost. The court's going to order a $1,000 fine per statute. It's up to $1,000, $100 screening assessment fee, $1,200 supervision oversight fee. That's 24 months at 50 months. I'm sorry, at $50 per month. If you are discharged early for probation, sir, then up to half of that, or then the part that you're not on probation anymore, sir, that portion would be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. The court's going to order $3,427 in restitution upon the proof that Mr. Cunningham is responsible for that. So that's $2,725, then plus the restitution portion that brings it to $6,100, approximately $6,152. You can set up that payment plan upon your release and return to work. Keep your hands out of your pockets, sir, please. Any questions?
Take Ron.
That did indicate you're eligible to request early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation reports have been completed. You've had at least all probation conditions have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Given that this is a large amount, sir, you just have to make sure making your payments monthly and timely and so forth.
Thank you.
Have a good day. So let's go on the record in the matter of the city of Wyandotte versus the Lawrence Bartoloni, 251674A. Counsel, your appearance, please.
Your Honor, good afternoon. Richard T. Serrano, P. 33828. Your Honor, today I appear with MIDC counsel on behalf of confined presently in custody in Wayne County Jail. And I appear today to time for sentencing, Your Honor. Please state your name, sir.
Lawrence Attilio Bartoloni.
Okay, very good. Thank you. And sir, I do appreciate your patience today. Your attorney has had a significant number of cases that were a little bit more complex than what is typical. And then I had a meeting at 1 o'clock that I couldn't move because that person had a meeting at 2 o'clock afterwards. So I do appreciate your patience today, sir.
No
Great.
problem, Your
That's
Honor.
all. Today's the date scheduled for sentencing on your client's plea to, operating while visibly impaired. And we had adjourned it because your client, I don't know what happened with that thing now. Can you turn it down again, sir?
Turn it down again? Okay.
Yes.
Is that good?
I don't know. Is that?
Cause I
Yeah,
can
that's
barely hear you now.
Well, I'm trying to not have it reverberate because if your volume is up higher, then it's difficult to hear. Then there's all that feedback or whatever it's called. So your client was set to be sentenced February 9th. Your client we did not conduct the sentencing on that day because your client was interested in treatment court. Further, your client said that he had a pending OWI case in either the 25th or the 28th district court.
It was Southgate, 28.
Okay. Well, doesn't seem to have it there. I don't know what's going on over there because it doesn't seem to be there. But then he says that he's a victim in a case at 28th district court. So I don't know. All I know is that Ms. Shine had sent over the paperwork for Mr. Bartoloni to the treatment court to 25th district court, yet they've claimed that they didn't receive any of it. So that's where we're at.
Well, may I put him to the question if he wants treatment court, Your Honor, at this point?
Yes.
Mr. Bartoloni, do you want to engage in treatment court in another court to take care
Wait,
of?
I can't hear nothing.
Oh,
Okay, sir, then I guess turn it up, but then I don't know if you're going to be able to hear it with all the reverberation from the cinder block.
I know, I can hear the verbiation too. Is that better?
Well,
Okay.
So far it's okay.
did you hear what I said, Mr. Bartoloni?
No, I didn't.
Okay. Are you interested in a treatment court through another court? It's an intensive program to help you cope with any problems you may have concerning alcohol or drugs. Or do you want to remain and be sentenced today as a non-treatment court client?
No, I can go to treatment court. I understand.
Okay, so then counsel, what we're going to do is I'm going to convert your client's bond to a personal bond, have him released with the tether, and we have to resend it to the 25th district court because they didn't get it to be able to interview your client.
Will he still be in custody, Your Honor?
No, I just said I'm going to convert it to a personal bond,
Oh, okay.
and then he still has to have the alcohol tether though. All right.
He tells me, if it's accurate, he tells me he's been in custody for 5 months for this matter alone.
Well, let's see here. No. Well, December 8th, January, February, March, 3 months.
I don't know. They all go. Didn't you tell me 5 months, Mr. Bartoloni?
Pardon me?
Didn't you tell me 5 months you were in custody?
I got in there before my birthday and that was in December.
Okay, well, it's not.
December
5 months,
16th.
All right. Well, you're going to be in good hands in treatment court, so we'll get another date then, Your Honor.
Yes. All right. So, sir, I'm going to convert your bond to a personal bond. All right. Because you've not been able to post your bond, and that there is some sort of administrative mix-up by the 25th district court because the referral was sent February 10th. So, sir, we're converting it to a personal bond, $7,500 personal bond, and then you just have to have the alcohol tether before you're released. Okay, so you'll get the
Okay.
alcohol tether, and then you can be released.
Okay, I get you.
You hear all that? Okay, very good. We'll see
Yeah.
you back short. We'll see you back. You'll get notification of a new date, sir.
Thank you. Your Honor.
Okay,
Thank you. Have a good day.
thank you, you too.
Does the court need to do anything with any of the people in the back of the own?
I don't know. I'm just doing as I'm told. I don't know.
No.
Okay, let's go off the record for a moment.
See you Wednesday. Thank you.
You're welcome, Mr. Serrano. Thank you for your day today. Okay, this is the matter of the city of Wyandotte versus Robert Jenkins, 26388 A and B.
Good afternoon, Your Honor. Your Honor, John Bolt, P 30758 on behalf of Mr. Jenkins. Mr. Jenkins, please put your name on the record.
Patrick Jenkins.
All right, did that come through, Autumn?
Yeah.
Okay, very good, thank you.
Your Honor, as to the claim,
Okay, good afternoon. Okay,
I'm sorry,
no, that's okay.
as to the claim, I extend the charges, waiver for meaning of those charges as the.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. Schedule this matter for pretrial April 8th at 10 a.m. All right, Mr. Jenkins.
Yep.
I'm sorry, I'm writing Mr. Jenkins. Mr. Goldpaw has to bond.
Your Honor, Mr. Jenkins is 35 years old. He is single. He lives with his father on French Road in Detroit, where he helps take care of his father. He's also gainfully employed, has been for the last 2 years at the Green Dot restaurant in Detroit. You got great sliders.
Green Dot Stables? Yes.
Stables, Your Honor. He has no prior criminal record. We're asking for a personal bond in this particular matter.
Okay, Mr. Jenkins, you help take care of your dad. Okay, is he disabled?
Yes, he had, he can never work. He had got injured at Walmart and he had to have surgery on the back of his neck.
Okay,
So
so I
just helped him
understand
out.
that, but so, okay. Have you ever failed to appear in court for any reason, sir?
No,
Currently on probation or parole anywhere?
no probation.
Are you out on bond in any other jurisdiction?
No, ma'am.
If you were to test right now, sir, what's in your system?
Only marijuana, ma'am.
Marijuana.
Marijuana.
Okay. Do you have a valid prescription for that, sir?
No, ma'am.
All right. So when's the last time you used marijuana, sir?
When I got off of work last night, ma'am.
Okay. So all right. So moving forward, sir, you're not to possess or consume any alcohol or drugs that are not prescribed.
Yes, ma'am.
You don't have a medical marijuana card, do you?
I'm sorry.
That means marijuana as well. Understand that. You're not allowed to use marijuana without a medical marijuana card from your primary physician. Do you understand that?
Yes, sir.
Okay, just wanted to make sure that, right?
Okay. And so the court's going to note, based upon the nature of the charges in this matter, and that the court's going to order a $2,500 10% bond. And you're not to possess or consume any alcohol or drugs that are not prescribed. All right, sir. So you got a copy of your bond conditions, and then we'll see you back on April 8th.
Thank you very much, Ryan.
Only two more. I'm so very sorry about that. Is there more than two?
No, just
one of them. Okay. All right. We're on the record of the matter of the city of Wyandotte versus Dennis Arquette, 2315551A. Well, good afternoon. Counsel, your appearance, please.
Your Honor, John Goldpaw, P 30758 on behalf of Mr. Arquette. Mr. Arquette, please put your name on the record.
My name's Dennis Arquette.
All right. Well, you're in custody. Well, there's a warrant for your arrest because you failed to appear for sentencing on November 1st, and you appeared to not have walked in voluntarily. So, counsel, the court will the warrant's recalled, And, we'll have to reschedule this for sentencing because I'm not sentencing somebody that's been 2 years
I
from
understand that.
information. So, I presume I should just pick a day. Well, their probation, I don't know, they'll have to pick their date. I don't know their schedule. Okay, as to bond.
As to bind, Your Honor, as the court indicated, this is he was picked up in an automobile last night. In fact, he was picked up at the same time that Mr. His name was Nelson. We just arraigned. They are roommates, as he indicated. He lives roommate. I just learned that.
Wait a minute, the one with the 3 cases from 2018 that
No,
we're
no.
talking? No.
The 2 cases.
Oh,
20.
Kaczynski.
Yes.
Okay.
Yes. Your Honor, he is presently, you're not working now. You're unemployed. Is that correct? You're going to,
I'm disabled.
you're disabled. Your Honor, he, when we reviewed the matter, he indicated that he had no excuse. He just failed with the sentencing. He completed and complied with all of it appears reviewing the docket entries that he had his PSI interview, and that was forwarded to an attorney. It appears, at least according to that, the reason he is here was his abilities just basically didn't do it. That's all I can tell you. Is that correct, sir?
I didn't think. He didn't have a seatbelt on, so they said, they want to give me a ticket.
No, sir. No. We're not talking about, no. Why you didn't show up at your sentencing back in September of 2023.
I moved and I didn't get the forward. I didn't get it. I spent 2 months in Wayne County Jail in June of 2023, and they said that would cover. The judge said that.
Sir, you moved from the Almar Motel, correct?
Right.
Okay, so then did you notify anybody? Did you change your address with the post office, with the Secretary of State? Did you notify anybody of your new address?
Oh, I spent 2 months in Wayne County Jail, and the judge in Southgate said, "Oh, they want you in Wyandotte, so you spend 17 more days in Wayne County Jail, and that would take care of Wyandotte." The way I understood it.
Well, sir, I can tell you that another judge isn't sentencing somebody in my court. That's not how that works. So
she said Wyandotte, and just assumed. And I was there 2 months, so for misdemeanor.
we're there for something else. And then after you got out of Wayne County Jail in August is when you picked up this case. So this shows August, so June 20, you were in this court August 29th to 23 for your arraignment. So you're out of custody at that point, sir.
I was in court here.
Yes, sir. In 2023, when this offense occurred, you were in court. That's how I knew you lived at the Almar Motel, sir. I didn't just.
I haven't lived there in several years.
At the Almar Motel?
Yeah, I lived down there in 2023.
I have that.
Okay.
I have his new correct address.
It was all figured out.
Well, sir, just so you're aware, you signed the advice of rights form August 29th to 23, and then you indicated homeless. But then on the record, you indicated Almar Motel. That's why I wrote that down. So otherwise, I wouldn't have known where you were staying, sir. Sir, how are you in custody?
Your Honor, he was in the vehicle that was stopped. Mr. Brzezinski was the driver of that vehicle. And he was questioned. He talked to the officers. and they ran both individuals, found that warrants were outstanding.
All right. And so, sir, do you have warrants anywhere else?
No,
Are you out on bond in any other jurisdiction?
no,
And if you're to test right now, sir, what's in your system?
nothing I know of, trying to think I am. I smoked some marijuana, yeah, probably.
Okay. And do you have a valid prescription for marijuana?
No,
Okay. All right, based upon your previous failure to appear and the multiple locations that you have resided at, the court's going to enter a bond of $5,000, 10% bond.
I promise I will show up for court. I did not know I had a court date. I will make it there. No reason to keep me in jail anymore. I will be there, I promise.
Sir, you had you had 2.5 years to still come into court or to contact the court to see if there was anything still pending. You did nothing. So that's the order of the court.
Well, I found I spent my time in jail and it was taken care of. I really had.
That was with the 28th District Court, sir. So if you're unsure, then you contact the court. You did not do that. We'll see you back April 8th.
I was taken care of.
We're all done, sir. We're all done. We're on the record in the matter of the city of Wyandotte versus Evelyn Cook. Off the record. Yes.
Well, I thought you were going to
No.
see if
Oh, no. I'm sorry. No, I did not say, if I said April 8th, I'm incorrect. That's going to probation for a new date.
that's correct.
Yes, that's my fault.
Thank you.
Thank you. All right. And we are on the record in the matter of the city of Wyandotte versus Evelyn Cook, 26390.
Correct.
All right. And counsel, your appearance, please.
John Goldwalk, P3L758. Ms. Cook, would you please put your name on the record?
My name is Evelyn Cook.
All right. And so we are going to conduct the arraignment, counsel, since your client's in custody, as to the arraignment.
Thank you, Ryan. You're right, that's, plead not guilty. Standing to the charges, waiver of fault, and ask for plea of not.
All right, the court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment.
Gotcha.
Schedule this matter for pretrial, April 8th, 10:15 a.m. It's to bond counsel.
That's the bond, Your Honor. Ms. Cook is 58 years old. She is presently on probation, out of the Third Circuit Court. She is gainfully employed as a home care nurse. She is single and she lives with Mr. John Bartola. My understanding in reviewing the report is that the police arrived and because of quote suspicious activity, according to the report, and that Miss Cook met them at the front door and handed over a bag of suspected narcotics. She also explained to them what was going on, and they did an investigation, subsequently arrested her, and she's been in custody since 24-26.
I thought your client looked familiar. She was just here a couple months ago. Well, 4 to be exact.
Yeah, it was a while ago because I'm sure that she's on probation, as I've indicated.
Right, for felony,
Attempted possession, I believe.
No. She had felony matters. No, pled guilty. Oh yeah, to attempt felony controlled possession.
Right.
Also, she had another felony possession charge dismissed.
That was the same case.
No, it wasn't. That was from Flat Rock. In 2023 that she didn't take care of until apparently she was in custody on the Wyandotte case. And then she also has a bench warrant out of the 33rd District Court
Okay.
for larceny.
You know, I also noted, Your Honor, just for these purposes, I noticed that there was a request, and it's for the purpose of bond condition. We're asking for a personal bond in this particular matter, the one which she can reasonably make, so she can continue her probationary status with the Third Circuit. I also note in the file, this matter was sent down to the Wayne County Prosecutor's Office, and they denied the warrant, stating insufficient evidence to prove beyond a reasonable doubt. Each person can, address each issue. I'm only bringing that to the court's attention because looking at what is in the report, this wasn't, it was unusual when I read it. And so therefore, I'm asking for a personal bond to run whatever her bond conditions are, and so this matter can be addressed.
Why does the name John Bartoletta sound so familiar? Does he have a case here?
I do not know. Your
He's disabled, Your Honor.
What is that?
He's disabled. He's handicapped. I take care of him. He was on 571 St. John Street.
Oh, yeah, we know that. Don't worry about that.
Right.
Ma'am, if you're in a test right now, what's in your system?
With nothing. I don't do nothing. I don't have a prescription for nothing. And my daughter is a doctor and a surgeon, and I was told by an X-ray and MRI that I had a brain aneurysm on the right side of my brain.
Okay, so would that cause you to test positive for something?
No, it's just, no, ma'am. I was just saying that's something that's wrong with me. I don't have.
Okay.
I take blood pressure pills.
Well, given the fact that your client has multiple warrants out for arrest, ma'am, and also who's Mr.
This courtroom hearing takes a serious turn as the defendant faces the consequences of a case that has now reached a critical stage. The court carefully reviews the circumstances, the arguments from both sides, and the defendant's position before deciding what should happen next. What makes this moment especially important is that the defendant's future could depend heavily on how the court views the evidence, the seriousness of the allegations, and whether the defendant has shown genuine accountability. At the center of this courtroom hearing is Michael Winquist, a defendant facing extremely serious allegations and multiple criminal charges. Both the prosecution and the defense had reached a proposed plea agreement and asked the judge to approve it. But from the very beginning, the judge made it clear that this was not going to be a routine approval. She explained that accepting a plea bargain is not automatic. Even when both sides agree, the court still has a responsibility to decide whether the agreement truly serves the public interest. The judge described the decision as extremely difficult. According to the allegations and information before the court, the case involved serious physical and emotional harm, including the impact on a juvenile. The judge explained that she had reviewed the criminal complaint, hearing transcripts, the defendant's admissions, arguments from both attorneys, and an impactful statement from the victim. But after considering the entire proposed agreement, the judge said she had serious concerns about whether the deal was appropriate as a whole. One major concern was the defendant's alleged conduct and history. The court noted that Winquist was on active probation and subject to an absolute sobriety condition. The judge also stated that as a convicted felon, he was legally prohibited